Please bear with us, good people. Our presenter is still trying to connect. Is currently having some issues with connectivity, but I'm pretty sure he's going to be able to connect anytime from now.
Colleagues, good afternoon. Are you able to hear me?
Yes, we can.
Yes, Lumando, I can hear you. Thank you.
Yes, loud and clear.
Thank you very much, and also yes, thank you very much for that feedback. Let me start by apologizing for starting a little bit late, and thank you, Mr. Lwando, for holding it up for me in the meantime. We are struggling with network connectivity. I think that is why we joined a little later. I actually tried to join earlier around 1:45. Unfortunately, as we're trying to check the system and everything, connectivity, I was just kicked out, and yeah, so that's the challenge, and I want to apologize for that. So colleagues, my name is Kaifas Umani. I am working at the Department of Home Affairs in the Transformation and Gender Directorate. So in our area, we are particularly responsible for anything or for advancing, among others, gender rights for all persons in South Africa who interact with Home Affairs, whether it's employees or whether it's our clients. So I'm also gonna be conversing with you while also checking with our main speaker today if she's able to join, because we also had some challenges with regard to network and so forth. So colleagues will remember that in 2018, women of this country marched in the total shutdown movement to raise concerns about a number of challenges that we have in South Africa. And that culminated into the presidential summit that was held in, I think, November of that year, 2018. So after the summit was held, as we all know, there was an interim committee that was put together to advance or address the issues that were raised during the summit. And one of the areas that were dealt with was that the country needs to develop a national strategic plan to address gender-based violence and femicide. And maybe as a way of reminding you, the vision of that NSP is to root out all of forms of gender-based violence, particularly those directed at women, children, and persons from the LGBTIQ community. So that is the background that we have. So when you look at that NSP, you then realize that it gives different obligations to different institutions. Yesterday, we had a session with Department of Basic Education, where they were taking us through some of their inputs insofar as dealing with GBV issues in their area. So even in the case of Home Affairs, there are a number of areas which the NSP says we need to address, and one of them is marriages. Sorry about this. Let me just check with Madam Agnes. All right. Thank you very much. Sorry about that, colleagues. I was just engaging with Madam Agnes, who was indicating that she is in the lobby. So, Mr. Luando, assist her to join in so that we are able to continue. All right. So, before that interruption of a call, I was just explaining the specific areas which the NSP calls for Home Affairs attention. And the NSP makes two critical areas that as Home Affairs we need to pay attention to. One has to do with marriages, and the other has to do with trafficking. So today in this webinar, which is titled GBV Amendment Acts, and we are focusing on customary marriages and related amendment acts. we will then be paying particular attention to what the NSP says Home Affairs must do, which is specifically in regard to, I think it's pillar 3 of the NSP. It says we need to pay attention to issues around customary marriages or amend specific areas relating to customary marriages. So as I indicated, today's seminar will be dealing with that area of customary marriages so that we have a sense of the specific amendments that have been effected. But maybe I should also indicate that if you look at pillar 3 of the NSP, it was not quite specific in regard to what are the areas of concerns or which areas do we need to amend, but it did indicate that we need to pay attention to customary marriages. So one of the areas we then had to deal with, to look at some of the judgments that courts have been dealing with over years. And I think Madam Agnes will be talking to that more in more details. So in 2009, there was a case in the Constitutional Court, that was between Gumede and the President of South Africa.
Hi, I think we lost the speaker because I cannot hear anything anymore.
Yes, I think he has sort of a problem, as he stated before, because he's not in the meeting, he just left. I'm not sure what's really happening. I'm trying to contact him. Sorry for that.
Hi, Luando. Luando, are you able to get the facilitator? Because if we can have the facilitator starting the session.
Yes, ma'am, I'm trying to call her, but she's not picking up.
Even the facilitator is not available.
Apparently, they are both in one office and they are all struggling with the network. So can we just give them a bit of time and see if they're going to be able to actually connect?
Would you please suggest to them maybe to use a different device? Luando, just talk to them, eh? I'm going to take over with the acceptance of people.
I did phone away. Let's
To mute.
Yeah, we can hear you now.
Okay. Colleagues, sorry once more about that interruption. Yes. Ma'am Agnes, are you in now? Are you with us? Okay. It also appears that Madam Agnes is also facing difficulties with connection. We apologize, colleagues. unfortunately, these are some of the challenges that you will have when you connect online. I think Madam Agnes has joined. Let me just quickly wrap my introductory remarks, and then I will hand over to Madam Agnes to go ahead. Yeah, so as I was saying, the NSP was not quite specific in respect to the specific amendments that we need to deal with as a department. But then when you look at CEDAW, there's actually a clause there that says, that talks to rights of persons in marriage during and before marriage, or rather when the marriage ends. So our previous act, or rather principal act of the Customary Marriage Act of 2000, it puts different regimes in terms of how we regulate marriages and all of that. So Madam Agnes will be talking to a number of issues regarding how customary marriages are regulated. And in particular, she will also delve on the changes that were introduced in the Customary Marriages Amendment Act of 2021. So, Madam Agnes, because we actually behind time, let me allow you to take over, and then you will make your presentations or your presentation, and then when you are done, we will then give colleagues an opportunity to engage on your presentation, whether in the form of questions or in the form of making comments. Madam Molefe, over to you.
Good afternoon, everyone. Can you hear me? I am not so sure because I have a connection problem from this side. I've
Yes.
tried to connect from my other.
We can hear you.
We can hear you.
Okay, yeah, I'm very sorry. I'm very sorry about that. That was just, yeah, one of those things. Yeah, my name is Agnes Molefe. I'm the Senior Legal Administration Officer in the Department of Home Affairs, with the drafting section, Legal Services drafting section. And I'm going to present to you the Recognition of Customary Marriages Act and the changes that comes with it. I don't know, because I was I was having a connection problem. How far have you gone, Kaifas, with the introductory background? That is fine. Let me just start.
Okay. Agnes, this is
Yes.
Advocate Praise Kambula.
Okay.
You have switched on your camera, but we cannot see your face. If you can just readjust your camera.
Let me just,
because this presentation is gonna go to YouTube.
Okay. Let me try, because I'm
That's
using
just
my
lower. All right,
Can
then we can see you. All right, Debucho, would you please switch off your camera? We request that you switch off your camera. Thank you. We can see you, Agnes, and your lighting is quite good. So thank you so much.
Okay. Yeah, as I've said, my name is Agnes from Home Affairs. Yeah, let me start with the presentation. I think I'll just give you a brief background, because for me to go straight to the changes, it's not going to make sense if you don't have the whole background. So I just have a summary of the act on the slides here. Like we have said, before the coming into operation of the act, that is the 15th of November 2000, customary marriages were not fully recognized, as you all know. And it was given limited effect and rendered subordinate to civil marriage. Like, for instance, when a civil marriage, the civil marriage had the effect of terminating a customary marriage. and placing a customary marriage wife in a precarious position should a husband conclude a civil marriage with another woman. Like for instance, if a husband can leave, a man can leave.
Madam
Hello?
My
Agnes?
apologies again, Agnes.
Yes.
You
I just
shifted
wanted to
from the
say,
camera. If you can just set it and not move it.
Oh, okay. I think I need to put it where it's stable. Let me just put it here on the laptop. Because now
Okay.
I was.
and then I just also want to check, Madam Agnes, are you also able to project the slides while? Yes, if it's possible,
Yeah, but
you can
you
project.
can help me as well from that side because now, like I told you that I have a problem with my laptop. Sometimes it locks itself off, so you can also open yours in the mix so that when it goes off, then you are able to help me, assist me from that side. Okay. Okay. Yeah. Now I was saying that a civil marriage had the effect of terminating a customary marriage, whereby placing the customary marriage wife in a precarious position should the husband conclude a civil marriage with another woman. So the civil, as a result, the civil law wife would enjoy precedence in terms of inheritance claims. So therefore, the act was enacted in order to place the customary marriage on an equal footing with the civil marriage in terms of matrimonial consequences, at the same time whilst recognizing certain customary practices. And in terms of Section 2 of the Act, we're saying that all valid customary marriage entered into before and after the commencement of the Act, that is 15 November 2000, and which complies with the requirements of the Act, are for all purposes regarded as marriages. Because previously, as we know, that they were not recognized as marriages, but in terms of the Act, now they are recognized. And in terms of Section 3, outlines the requirements for the validity of customary marriages. It says that for a customary marriage entered into after the commencement of the Act, for the marriage to be valid, there are certain requirements that needs to be complied with. Like for instance, the prospective spouses must be 18 years and above and must both consent to be married to each other under customary law. And the marriage must be negotiated, entered into, or celebrated in accordance with customary law. As we all know that in customary practices, like if a man wants to marry, he'll just approach the girl's family in order to negotiate for the lobola, and then the marriage will be entered into. There's something that in our culture, in our social culture, there's something that is called ikabiso, whereby they slaughter a cow or a goat or a sheep or whatever in order to signify that the marriage has been entered into. So a celebration, sometimes it's just a cherry on top. Sometimes some people don't even celebrate the marriage. They just assume that the marriage has been entered into and there's no need to celebrate. Because some people, most of the people, they prefer to celebrate it in a white wedding, kind of. But they can still celebrate it in terms of customary practices. So we are also saying that no spouse in a customary marriage shall be competent to enter into a civil marriage during the subsistence of such a customary marriage. So when you are married in terms of customary rights, you are not allowed to enter into a civil marriage with another woman, unless if with the same partner, with another.
Madam Agnes, it appears that we have lost you. Are you able to hear me? Madam Agnes, are you back on the line? Okay, colleagues, sorry about that. We lost Ms. Molefe a while ago. Okay, now it seems like she's back. Ma'am Molefe, are you able to unmute and then continue with the conversation?
Okay.
Just to interject you, I'm also trying to locate that presentation. If you may resend it, and then, or I'll also give you the email address of the coordinator from Department of Justice and Constitutional Development, Mr. Lwando. And then as you continue, then you can send it to both of us, and then we can flag it. I was trying to check it once more. It appears that my emails are upside down. Okay, so you can continue while trying to resend the presentation. Thank you very much.
Yeah, okay. The Act is also saying that no spouse in a customary marriage shall be competent to enter into a civil marriage during the subsistence of such customary marriage. If either of the prospective spouses is a minor, both his or her parents or legal guardian must consent to the marriage, as you all know, that we are not allowed minors to enter into a marriage unless they get the consent of their parents. And then and section 4 is about the registration of customary marriages. Yeah, the Act is saying that it is the duty of spouses of a customary marriage to ensure that their marriage is registered. Either spouse or any other, in terms of section 4(2), either spouse or any other interested person may apply to the registering officer of Home Affairs for the registration of his or her customary marriage, and must furnish the Lobola Letter and any other additional information which the registering officer may require. And the Act also categorizes customary marriages in terms of the time frames for registration. Like, for instance, those who were entered into before and after the commencement of the Act. As previously, the Minister of Home Affairs, in terms of the Act, the Minister of Home Affairs has to, from time to time, prescribe a period for registration of customary marriages entered into on or before the commencement of the Act. But now the latest prescription period was like up to the 30th of June 2024. So those people who did not register their marriage, they still have the time to come and register their marriages until that date. And then section 4 continues to say that failure to register a customary marriage does not affect its validity. As long as you entered, your marriage is valid, you don't have to register it in terms of the Act. It does not affect its validity. And then section 6 talks about the equal status and capacity of spouses. It says that a wife in a customary marriage has, on the basis of equality with her husband and subject to the matrimonial property system governing the marriage, yes, she has full status and capacity, including the capacity to acquire assets and to dispose of them, to enter into contracts and to litigate, in addition to any other rights and powers that she might have at customary law. And section 7 talks about the proprietary consequences. It says that a husband in a customary marriage who wishes to enter into a further customary marriage with another woman after the commencement of the Act must make an application to court in terms of section 7(6) to approve a written contract which will regulate the future matrimonial property system of his marriages. And I'm so glad that there is a justice also here. Maybe they can, because most of the time people are asking us about this contract, or what form does it take? How I mean, what is supposed to be contained in the contract? But sometimes it's very difficult as Home Affairs to explain to them or what kind of a contract is that. So I hope at the end of the presentation our colleagues from justice were able to help us in order to explain further or what kind of a contract is this. The case in question is the Nguyama versus Mailan. That was a 2011 case. They were speaking about the contract. And then there was also the issue of the consent, that the first wife must consent to the second marriage. So the husband in a customary marriage cannot enter into a second customary marriage or a subsequent customary marriage without consulting the first wife or getting the consent of the first wife. Proprietary consistency, section 7.2. So in a case of Kumele versus the President of the Republic of South Africa, it is a case that we all know that was in 2009. The case concerned about, is concerning a claim of unfair gender and race discrimination in relation to women who are married under customary law as codified in the KwaZulu-Natal Code. Underline the persistence of patriarchy and the vulnerability of women as victims. So the applicant in this matter approached the Constitutional Court for confirmation of a declaratory order by the High Court of the constitutional invalidity, particularly of Section 7.1 and 7.2 of the Recognition of Customary Marriage Act 120 of 1998. So the court confirmed the unconstitutionality of this matter, and then it says that traditional monogamous marriages were declared to have the same status as new monogamous marriage, which is marriage in community of property. So the KwaZulu-Natal Code was also declared inconsistent with the Act. So in this case, the proprietary consequences of a customary marriage in which a person is a spouse, that is the amendment now, we're talking about the amendment. The proprietary consequences of a marriage in which a person is a spouse in more than one customary marriage, and which was entered into before the commencement of the Act. No, previously we know that it was saying that it continued to be governed by customary law, but now it has been changed to say that it is now, the marriage is now, which was entered into before the commencement of the that the spouses in such a marriage have joint and equal ownership and other rights and rights of management and control over marital property. So which rights must also be exercised in respect of house property by the husband and the wife of the house concerned, jointly and in the best interest of the family unit constituted by the house concerned, and in respect of the family property by the husband and all the wives jointly and in the best interest of the whole family constituted by the various houses. And then Section 8 talks about the dissolution of customary marriages. It says that a customary marriage may only be dissolved by a court on the ground of irretrievable breakdown of a marriage relationship, whereby the relationship has reached such a state of disintegration that there are no prospects of restoring a normal marriage relationship between the parties. So the case in point is Southern versus Morapan, whereby the court dissolved the customary marriage, though it was not registered. But now, in terms of Section 4.9, the parties will have to prove that there was a marriage. So in this instance, most of the time, the courts refer the people back to us, the parties back to us, to say if the person wants to file a divorce proceedings, but the marriage was not registered, they first refer the people to whom I first to register the marriage first. And the case in question is Southern versus Morapan, but here the court dissolved the marriage without the marriage being registered. But in Lobola versus Gube, that was a 2008 matter. It says that only a competent court may dissolve a customary marriage. So once you have paid Lobola and the marriage has been entered into, there's no way in which you can say that you don't want this wife or this husband anymore. You have to go to court and follow the correct divorce proceedings. But it can only be dissolved by a court of law. So Section 10 talks about the change of the marriage system. Spouses in a customary marriage are competent to contract a marriage with each other under the Marriage Act. That is the Civil Marriage, the Marriage Act of 1961. If neither of them is a spouse in a subsisting customary marriage with any other person. So they can only complete the marriage with each other, not with any other person. So once a person is married, a husband is married like more than one wife, there is no way in which he can enter into a civil marriage. He can only enter into a civil marriage with the same wife. So as we all know that civil marriage are monogamous in nature. So they don't allow you to marry more than one partner. So no spouse of a marriage entered into under the Marriage Act of 1961 is competent to enter into any other marriage. Although we have so many cases that are like this, because I think the reason was because the customary marriages were not registered. So when the husband comes, let's say for instance, the husband comes from the rural areas and comes to Gauteng. When they meet this nice lady here, decided to get married, the system does not recognize that this person was already married. So they enter into a civil marriage, not knowing that this person has already entered into a customary marriage before this one. So it results into a bigamous marriage. So this is one of the problems that Home Affairs is dealing with. Thank you. Help us. Yeah, I'm done. Thank you. Help us.
Hello, I can hear you.
Can you hear me now? Yeah.
Yes.
And
Okay. Thank you very much, Madam Molefe. Colleagues, we apologize once more for the challenges with technology. I'm not sure it's because today we're talking customary marriages and, you know, network, it's quite another thing. It's not so customary today, but we do apologize for the hiccups we've had. And we also apologize for the challenges in regard to projecting the slides so that you are also able to follow through as Madam Molefe was presenting. So all of this is because of the technical glitches we've had, and we sincerely apologize for that. But I want to hope that we did get a gist of Madam Molefe's presentation. She did take us through about some of the issues that talk to regulation of customary marriages, such as matters relating to how a valid customary marriage is entered into, issues of equality. But then maybe just to add a little a point on what she was emphasizing, is to note that if you look at CEDAW talks about equality of marriages between spouses during and even when that marriage dissolves. So in some of the cases that she made reference to, such as Gumede, the Recognition of Customary Marriages Act of 2000 only conferred rights of control to the husband, and the wife, you know, did not have such rights. So the Amendment Act seeks to deal with such issues to ensure that there's equality in marriages, whether during or even after the marriage. So those are some of the points that she raised that you need to be aware about. And then she also highlighted issues about contracts. I'm not sure if anybody from Justice may want to comment about that. or maybe it may be an issue that we look at in another webinar, because you know, automatically when people get married now, in a customary marriages, it is a marriage in community of property, but spouses still have a choice that should they do not want their marriage to be in community of property, they can sign an antenuptial contract and indicate how they want to their marriage to be regulated. So I'm not sure if anybody from Justice may want to add more light on that before I allow all of you to make comments as well as to raise questions. Anybody from Department of Justice to address that area? Okay. Maybe it may be a matter that we address in another webinar, which is okay. Maybe let me then allow colleagues who are on the line to raise questions of clarity or to make comments on the presentation. I see let me shorten it and call it Marlo before I butcher the name. Marlo, you know, I'm very sensitive to names. I'm one person who's been wrongly called a number of times, and it doesn't feel okay. So before, yeah, so I do not want to do the same with other people. So Martha, you'll go ahead, and I see Rev SK, you will follow after Martha. In that order, please.
Okay, I'm Ceci Matlobokwane from the Department of Higher Education and Training. My question is a simple one that says, we know that normally in community of property, the couple will divide their assets equally. Each one gets a 50-50. But now in the case of a customary marriage where the man has decided to marry more than one wife, how is it done? Is it the 50% goes to the first wife and then he shares his 50% with the other wives, or they all get an equal share as they get added to the equation? Thank you.
All right, noted. Rev SK, may you go ahead, please.
Thank you. Mine is about the customary marriage of these two couple. In a way or another, they ended the relationship or the marriage, but the marriage was not registered. Now the husband wants to marry another woman. What is the procedure? Does he have to go and register the marriage and divorce officially the first wife, customary so, and then enter into the new marriage, the civil marriage now? Yeah.
So, sorry, I didn't quite get what.
Okay.
You said
the
husband,
they are married customary. Yes, they're customary married, but for a couple of years they are no longer together. Let's say for 5 years they are no longer together. They ended the relationship in 5 years, and then after 5 years the husband gets another wife, and then the husband is going to marry now the second wife. The first marriage was not registered. It was a customary marriage, but it was not registered. And then they break away. They parted their ways. And then after 5 years, the husband gets another wife and then gets into marriage with the second wife, the civil marriage. How is it possible to continue, or does he have to follow the procedure of registering the customary marriage and then divorce officially, so before entering into the second marriage, which is the civil marriage? I don't know if I'm clear now.
Yeah, I think I got what you're trying to say. Yeah. Okay. Can I answer now? or is you still have more questions?
Maybe before you answer, I see Kineilwe, you can go ahead and then Madam Agnes, you can respond.
Okay, in the absence of, let me just respond and then Kineilwe will come back because I don't
That's
know what
fine.
to say.
That's fine. That's fine. You can respond to the two issues, and then right after we'll give Kineilwe an opportunity to ask or make a comment. Thank you.
Okay. Yeah, I'm also glad that my former boss, Advocate Bulemich, is also here. So you will also help me. You also chip in and then add on some issues that you feel that maybe I left them out. And I'll start with the second question, whereby the question was when the husband has already married, like, and then he left the wife for 5 years, something like that. So, but remember we said that in terms of the act, it will depend when did he marry this wife. But if it was after the act, after 2000, it means that husband cannot enter into this marriage before divorcing that other one because he's still married in terms of the act. Remember we said that only the court of law can dissolve the marriage. So the husband has to go to court first to dissolve this marriage before he can enter into the second marriage. You cannot just abandon your wife to say, I don't want this one anymore without going to court. You have to go to court in order to dissolve your marriage, like legally so. I don't know if I've answered you. And the other question was about the 50-50 share between different wives. Remember we said that now with the introduction of the act, there's a provision that the husband that wishes to enter into a second marriage must come up with a contract, must draw up a contract if you want to enter, because already you have property with the first wife. So if you want to bring the third person into this, you have to draw up a contract and submit it to court. So that in the contract, you are going to outline how are you going to divide your properties amongst your different wives, depending on how many wives are there. Yeah. So my colleagues will also add if I've left something. I don't know if I've answered.
All right. Yeah, maybe just to chip in, Madam Molefe. I think it must be known and clear to all that Section 9 of the Recognition of Customary Marriages Act says a customary marriage is valid even when it's not registered with the Department of Home Affairs. So registration is not a requirement for validity of a marriage. So hence, Madam Molefe is saying that if one is married customarily and then after some time decides to marry without divorcing that first wife, that marriage will be valid because in the first place, it was valid. So with other forms of marriages, like for instance, a marriage entered into in terms of Marriage Act of 61, it may be necessary to register and all of that, and it becomes an issue that's considered. But with customary marriages, it can be valid even when it is not registered. So to end such a marriage, divorce must kick in, otherwise that marriage is still valid. And that will have an effect on the second marriage that this person wants to get into. And of course, if one is married customarily and wants to marry a second wife, I think it's Section 7 of the Recognition of Customary Marriages Act. It says the husband must go to court so that they deal with the proprietary consequences of that marriage. Because you remember that if you are married to one spouse, that marriage will automatically be in community of property. But then when you then want to marry a second wife, then the court will have to evaluate the contract these people are bringing to check whether it's fairly distributing assets between the people that are married. And if the court agrees, that the contract that's been drafted equitably and reasonably distribute assets of that marriage, then the court will give that marriage a blessing. Otherwise, there may be an issue there. That is why when you look at the new changes that have been effected in the Customary Marriages Amendment Act of 2021, the law puts a regime in regard to how you deal with the things that people collect during marriage, and it gives guidance in that respect. So I think those are some of the points I would like to add based on the questions. Let me allow Rev SK as well as Kineilwe to go ahead with their questions. Colleagues, go ahead in that order, please. Thank you.
And okay, before they can say anything, let me just add, or in terms of section 76, I agree the act is saying the husband, must submit a contract, a written contract, which will regulate the future matrimonial property system of his marriages. I agree that was also said, if you want to marry a second wife, in terms of the act, then you need to have the consent of the first wife. So that wife that you left 5 years ago is still your wife. So you need to get her consent before you can enter into a second marriage. There is no way in which your husband can just go and marry another person without even consulting with the first wife. So in terms of the act, that marriage is still valid. So the husband still needs the consent of that wife. So for him to go and marry the second wife, he needs to go to court in order to divorce this wife before he can enter into the second marriage. Thank you.
All right. Thank you very much, Madam Mulife. Just before I allow the two colleagues, Rev and Kineilwe, to go ahead, I noted, I'm advised here that some of the colleagues have challenges in respect to raising their hands, and it appears that they've been wanting to say a word or two. So let me allow Advocate Tieti to come in, and then right after Rev, SK, and Kineilwe, you'll follow in that order. Advocate Tieti, go ahead, please.
After colleagues, actually, I wanted to ask a question. Since the facilitator indicated there might be helpful in some of the information, I just wanted to, yeah, can you hear me?
No.
Advocate said your line is not so clear.
Yeah,
it's quite faint. Can you try again?
Can you hear me?
Not so clear. Do you mind if I?
Not so clear.
Yes.
Okay. Let me join with a cell phone. Then I
okay. In the meantime, let me allow as you are trying to rejoin Advocate TNC, let me allow Rev SK and Kineilwe to go ahead. Thank you very much. Colleagues, in that order, please.
Thank you very much, Reverend SK, but I'm okay. I've got the answers. Thank you so much for the clarity. I don't have any question. Thank you so much.
All right. Thank you very much, Rev SK. Kineilwe. Kineilwe, are you able to hear me? I see your mic, it's unmuted. Go ahead, please. Okay, it appears that we also have a communication challenge with Gineilwe. I see Advocate Yeti Sibelemeje is back on the line. Advocate Yeti, are you able to, you can try again, please. Go ahead.
Okay, yeah, afternoon. Can you hear me?
Yeah,
Better.
Yeah. All right, thank you. I wanted to ask a question, but I'll ask at the end. But it's more related to us going forward in terms of the developments with regard to what is coming up as the Single Marriage Act. But firstly, maybe just to assist a bit in terms of what the speaker was talking to. I think is to first say, in a customary marriage, we should not take it that the husband is the only one who has to do everything that is required in relation to, registration of a marriage, because that's one of the challenges. And also, I see part of the questions on the chat as well to say, if you part ways and someone goes to marry, do you have to wait for the husband? It is upon either of the spouses to ensure that there is a divorce, because if you don't divorce through the courts, where you get a decree and you only negotiate as families, that is not recognized as a divorce, if at all the customary marriage is valid. Like Ms. Molefe indicated, a marriage is not only valid because there is a registration. And if it is not registered, you apply for divorce. You do two parts. You can have part A that talks to the court, firstly recognizing that the marriage exists. And if it does say, yes, the marriage exists, then part B talks about the issues of dissolution of a marriage. And thirdly, of importance, why the requirement is that a husband who wishes to marry a second wife must apply to the court, is to protect the current wife. And part of the agreement, there's a template that has been developed that you have to sort of fill in certain type of information. And Mr. Mahuman was talking to that. It does talk about the property that you would have acquired with the wife before you marry the second one. And also there's an issue around how are you going to deal with that property going forward. So the first wife, before the prospective wife comes in, should be protected first. And from there, there's an indication as to how are you going to deal with the property, movable property. If, for example, you're going to live within the same house, then how are you going to deal with it going forward? Because you would have acquired it during the existence of the first marriage. So there are safeguards that are existing. The unfortunate part is that we do not necessarily give much attention to the recognition that the customary marriage has been given, which is equal in every element as a civil marriage. And unfortunately, like during my time in my previous employment, one of the challenges that we have had was that the customary marriage, people will only approach the department for registration after death of one spouse, simply because when you knock on every door, they need proof that you are married. And unfortunately, if you have not registered your customary marriage, you will not be able to prove to anyone that you are married. So it becomes a difficult issue to prove or to convince anyone that you are married. So the one question that I wanted to raise to colleagues perhaps is to say, with regard to the upcoming and the court challenges that we have had with regard to, for example, Muslim marriages, and that the Department of Home Affairs, I'm aware, they've commissioned an investigation into a Single Marriage Act. It might be helpful to be able to give as to, are there any plans going ahead in terms of how we're going to deal with these current perceptions that people have about customary marriage, to strengthen or to just make sure that people are aware that all marriages are equal in the Republic, except in terms of the types. Of course, they will differ, but equally before the law, the consequences are the same and the like. Thank you.
All right. Advocate Tsietsi, thank you very much for the input. It appears that I'm not sure if you were done with your thought, but we
Yes,
are no
I was
longer.
done.
Okay, no, thank you very much. Yeah, I thought maybe due to it might be another network challenge. Okay, no, thank you very much, Advocate Sibelemicha, for your input. I suppose it's one of those important inputs that colleagues will also take to heart. I see Kineilwe, it's back. Kineilwe, you can give it a go. Kineilwe, if you also not able to, because I see on the chart you indicated that you also have difficulties with connectivity. If possible, you can quickly type your comment or question, and then we can deal with that before we wrap up. Let me see if I have another hand here. Okay, it appears okay. Kineilwe, are you maybe try again before okay. It seems like we still have a challenge with I'm hearing somebody. I'm not sure if you want to engage. I'm not able to see who the person is. Okay. Right. It looks like there are no further hands to ask questions or comment. Yeah, so I think that will be it for. Okay, I see Advocate Kambula. Advocate Kambula, you can go ahead.
Thank you so much. I think for the benefit of people, I wouldn't like this session to end without having addressed these two issues, which I believe that are quite common. One, if a person wants to register a customary marriage, what are the documents that are required? What is the sufficient information or evidence that is required? All right. And then secondly, because I think that a lot of people have got that question. Then secondly, if your parents got married customarily in 1960, how are they required to have their marriage registered, and how to go about doing that? Thank you.
Right. Thank you very much for the questions, Advocate Trace. Madam Molife, can go ahead and respond.
Okay, when you need to register your marriage and approach Home Affairs, we need a Lobola letter if it was there, or any other document or any other proof that will show that the marriage was indeed entered into. We also need witnesses from both families, like 2 witnesses from. It can be one, maybe, because sometimes we find that the marriage was entered a long time ago. So some of the witnesses are no longer there. But we just need people who can attest to the existence of the marriage from both families, from the husband's side and from the wife's side. just to support that, yes, we know about this marriage. It existed, and then this is what happens. Something like that. And a Lobola letter. That is one of the requirements. And the second, in relation to the second question, you said when the parents got married like a long time ago. I can't. What was the other issue again? Can they still come and register? Or what was the, I can't.
I think what she's trying to understand is that if people got married long time ago and they have not registered their marriage for the longest time, and in 2022, perhaps they want to register it, what it would be the process to register that marriage? I hope I'm representing you correctly,
I think,
Advocate Kambule. Yes, so that is the question, Madam Oliver.
Yeah, they can still come and register. Remember, I said that the minister has prescribed another period for the registration, because normally from time to time, the Minister of Home Affairs prescribes a period within which people can come and register their marriages. So they can come and register their marriage. The period of registration is still open until March 2024, I think. No, June 2024. Yeah, so they can still come and register the marriage and just bring the proof, or some people who can attest to the existence of the marriage. Because if it's like the marriage that was entered a long time ago, sometimes they won't have the Lobola letters or any other proof. But as long as they can bring the witnesses who can attest to the existence of the marriage, I think that should be sufficient. Advocates Village can also assist if maybe I left some of the issues that needed to be addressed. Thank you.
All right, thank you very much, Madam Life. I see that, okay. Advocate Sbelemeja, it appears you might want to add. Go ahead, please.
Thank you. I think one of the things is that if you have got from the former homelands, you have got the certificates under the homelands that was indicating that you were married, and you could also, submit them for updating the marriage. That's one thing that I recall that you can still do, because as long as those marriages are not dissolved through divorce, you can still go and update them. Thank you.
Thank you very much, Advocate Tieti. I see
just one more thing before we can get to other people.
Yes, follow up, Advocate Trent.
Yes, is the Lobola letter a prerequisite? If I do have maybe the photographs of us getting married, and we decided that no Lobola is going to be exchanged, and it's a customary marriage, can I register that marriage without the Lobola letter?
Lobola, sorry, can I answer? Lobola letter, Lobola is not a requirement in terms of the act. The act is not saying anything about Lobola. It's just custom that we follow. And even if you go and you don't have that, like I said, in the olden days, they didn't have the Lobola letters. But as long as you've got proof, like you are saying, the photographs or something just to prove that the marriage indeed existed, or the same certificate from the homelands, like it's saying, or any other document or any other proof, that will be sufficient for Home Affairs. As long as the registering officer can be convinced that indeed this marriage existed, it will be registered. Thank you.
All right, thank you very much, Madam Olive. But maybe just to add on your response, colleagues, if we look at Section 3 of the Recognition of Customary Marriages Act, it reads as follows. For a customary marriages entered into after the commencement of this act to be valid, the prospective spouses must be above 18, both must consent, and lastly, the marriage must be negotiated and entered into or celebrated in accordance with customary law. So I'm just reading this portion to also emphasize the point that Madam Olive is saying, to say the law does not say lobola per se, but it just says the marriage must be negotiated and celebrated. So it may then depend on people on how that negotiation goes about. If negotiation involves a certain amount of lobola, then that will be part of the negotiation. But if the negotiation excludes lobola, then that will be part of the a negotiation. So I think those are some of the elements we need to be aware about. And I see Mr. Mandiwane, and then Kineilwe, it's also raising the hand once more. Mr. Samuel, go ahead, and then Kineilwe will follow.
Okay, thank you very much, Kefas. I think some of the issues that I wanted to raise, they have already been answered. I know that this is more when it's more on, it's central to a man than women, but I just want to bring a spin on the same situation here. Say, for an example, a man is married to or more women, then all of a sudden, then he is no longer working, and maybe one of the ladies in a family situation starts to work and acquire so much properties, and it happens that the lady dies. Now we have got this husband who's no longer working, and these other women who are no longer working. What do they do with the properties that has been left by that lady that has passed on? Thank you.
All right, thank you very much, Mr. Mandiwane. Kinele can go ahead, and then I see Buku Benkosi also raising the hand. In that order, please. Buku Benkosi.
Okay, thank you for the opportunity. Good afternoon to everybody. Thank you very much for the very insightful presentations that have been made to us. So I've got this question, although I want to believe that it has partially been answered here and there, but I would like to be sure about the answer, because we are an organization that works mostly with women living in the rural areas. So now my question is, if I have a marriage certificate, does that mean my marriage is registered? Should I relax, or is there anything else that I need to do to make sure that my marriage is registered? Thank you.
Thank you very much for that question. Gefilwe, are you able to raise your point or question?
Okay, in the meantime, maybe I should answer, and then as long as
please.
We're still trying to reconnect. Yeah.
Please go ahead.
So the first question was in relation to the husband who married more than 2 women and is no longer working. And remember, we said that when if the husband wants to marry the second wife, they need to complete the contract, the written contract, whereby you will outline how he's going to distribute his assets among his various wives. That's what we said. And then you said that when the husband dies, what is going to happen to your property? I think the contract would have outlined what is going to happen to your property because I remember, I think when let's say the second wife joins into the marriage, now there will be communal property, isn't it? So when the husband dies, the contract would have outlined, or when I think when we're in the contract, I don't know what will be the context of the contract, but the contract will specify how many portions or what percentages are the wives supposed to be given in case in the case whereby the husband is deceased. So the court will have a look at the contract, the contents of the contract, because we said that, remember we said that for the wife, the husband to take the second wife, they need to come up with that contract. So the contract will specify the amount of the how the estate is supposed to be distributed among the wives. I don't know if I've answered to your satisfaction, but advocates will also assist in that regard as the people from justice.
All
and
right.
the second.
Okay, yeah, sorry about that. You can go ahead.
The second one is in relation to the marriage that is not registered. The marriage certificate. The marriage certificate is the prima facie proof that your marriage has been registered. So it is valid. It's like you don't have to produce any other thing. That is the prima facie proof that yes, indeed your marriage is registered. Thank you.
All right. Thank you very much for those responses. I'm wondering if the end of Mr. Samuel is not a legacy end, or whether it may be a follow-up of sort. You will advise.
It's a follow-up.
Oh, it's a follow-up. Okay, go ahead with the follow-up.
Listen, no. Okay, she has answered it, but if it's central on the husband, this time around, we are talking about these women that have been married in terms of the act, customary law. Therefore, the husband is no longer working. Then out of those women, among those women, one of them, let's say, start to work and acquire a lot of properties and the like. And now it happens that she dies. What happens to those the property of that woman? Not of the husband. The husband is still alive, but the woman has passed on. What happens to that, to those properties? That's what I want to know.
Oh, I thought that is the husband who died. Is the wife who's working now, and the husband is not. But remember, I agree the marriage will be in community of property. Okay. So we said that that property that the wife has acquired, it will form part of the joint estate. And it will be distributed equally amongst the existing wives and the husband. Because it is part of the joint property. I don't know. The application that civil measure will also assist. But that's how I understand it. Or if it's part of the joint estate, it's supposed to be divided equally amongst the wives. The existing beneficiaries, including the husband.
Advocate Svelvenja, do you want to come in?
You are muted. I don't know if he's still here. He is muted.
Okay. Yeah, but as I understand the question, I think it also has to do with the other area that I think it's also beyond the scope of this webinar, because generally, or in particular, this particular webinar, we wanted to deal with changes that have been introduced in the Amendment Act of 2021. But then there's also another area of law that deals with matrimonial property regime. I think that may also be of assistance to deal with the type of question that you are raising, Mr. Banduan. But maybe just to, as a way of also dealing with your question. When you look at the Amendment Act, it talks about 3 forms of property. The first one is family property, and there's what we call house property, and there's also what we call personal property. So in regard to family property, if it is, as Madam Molife was pointing out, that a particular form of asset falls as a family property, which must be shared by the husband and the spouses. So such distribution will then affect all the parties in that marriage, regardless of whatever number they are. But if we then find that a particular asset or property belongs to just a particular house, so that asset will then be distributed within that particular house. And of course, if an item is a personal property, then whoever owns that item may be the one who decides how that property gets set. So I think those are some of the dynamics that we need to be aware of. And maybe there may be an issue to ask which property is a family property, which one is a house property, which one is a personal property. And I think the courts, sometimes they may actually assist in that regard. But I think just to give you a broad sense to say, whatever assets that we are dealing with in a marriage, if it belongs to a family property, all parties in that marriage must benefit from it. If it's a house property, people in that particular house only benefit and exclude members of the marriage who are in other houses. And of course, if it's a personal property, it belongs to one person. I'll give you an example. For instance, if I have a cell phone, I have a sense that that type of thing may be a personal property. But if I have a stove that we cook in a particular house, that stove might be a house property that belongs to a certain house. But if maybe one has a business where all members benefit, one may begin to think that such assets may belong to house property. So for me, it would be, we look at that area and then we classify, and after classification and then allocation will happen. I think Advocate Svelemija, you are recognized. You can also assist in addressing the question. You can go ahead, Advocate Svelemija.
Oh, thank you. If I heard the question correctly, is the one raised by Mr. Mandiwan.
Yes.
Yeah. If the correct procedure is followed before the second wife is married, the contract that the husband and the wife and the prospective wife are going to sign deals with all the aspects relating to property. Firstly, you declare which properties do you have, movable, immovable, and how those are going to be distributed before the second wife comes in. Then when the second wife comes in, how are those immovable or movable properties in the future going to be distributed as well? So there should not be a challenge if at all the proper procedure was followed. Whether the husband or the wife is working in a marriage, remember we are equal in terms of contribution towards the property that we acquire. So we don't have to look at who's working and who's not working. The moment we start looking at that, I think it's just an unfair, type of a thing that happens in a marriage. So then the distribution should go according to the agreement that was a contract, or the contract that was signed. But remember, the courts as well still have an obligation, or they've got a discretion to do an equitable distribution as and when they are dealing with disputes. So that's what the law actually has designed, that things should flow properly. But unfortunately, if you don't register and or you later on you'll have this kind of challenges, especially when the other one passes on. But remember, that part of the estate of the late spouse should be also be distributed accordingly in terms of whether there's a will or there's no will. Then those rules or the procedures will have to apply. I think if I got the question correctly, I think that will be my contribution. Thank you.
Thank you very much, Advocate Tsietsi, for your insightful contribution. I note Advocate Praise, your hand is up. Go ahead, please.
Thank you. Just give Luando first because he's the one who raised his hand before me. Thank you.
Okay, Luando, can you go ahead?
Oh, okay, thank you so much. I'm not coming with a question. However, I wanted to sensitize you about the question on the chat box from Fantespino with some bit of a context. She says that some customary marriages have been disputed because even though it was negotiated, the bribe was not brought and received by the groom's family. But the two lived as husband and wife. How do we deal with this, as it is usually disputed after the husband has actually passed on? Do all the conditions need to be valid before it is recognized? And the other question from Wayne state that, well, just give me a minute. Okay. Will affidavits from witness be sufficient for the registration of marriage? And the last one, do the amendments address some of the underlying drivers of GBV contained in the counseling given by the leaders to the couple during customary marriage? So those are the questions that we have from the chat box. Thank you.
Thank you very much for that, Luando. And yeah, ma'am, Molefe, go ahead.
So I just had the first one dealing with the validity of the marriage, if I'm correct, to say that if the marriage is not registered, I didn't even write it down because now I can't. Let me just have a look at the notification. I don't know if, because I can't read the comments from my phone.
Okay, so the issue is from Mem as Fante. Should I quickly read through, or you got it?
Yeah, just one at a time, because like now there are many. I could not even write as quick as you were speaking. Yeah.
All right, let me quickly rephrase the one from Madam Spino. So she says some customary marriages have been disputed because even though it was negotiated, the bride was not brought and received by the groom's family, but the two lived as husband and wife. How do we deal with this, as it is usually disputed after the husband would have passed away?
Okay, remember we said that for a customary marriage to be valid, there are certain requirements that needs to be satisfied. One of the requirements is that the marriage must be negotiated, entered into, and or celebrated. And I think it depends on the different cultures, because in our culture, like the Lesotho culture, they're supposed to be after the negotiations, there's supposed to be the slaughtering of a cow or a sheep or a goat to signify the entering into the marriage. And once that is done, the marriage is concluded. You don't even need to celebrate it. The celebration is just a cherry on top. But some cultures, like the Swati culture, there's something like Uku Memeza. So some of the customs, they differ. But I think it depends from custom to custom. like in our Sotho culture, as long as the marriage, the entering into a marriage signifies that the two parties have agreed, the two families have agreed, the woman, the wife and the husband can stay together as husband and wife, even though, but in most cultures, like in our culture, there have to be this handing over of the bride to the groom's place, even if the lobola is not fully paid, because you know in our Sotho culture they say mosadi ha fail or mahadi ha fail. So as long as the family, both families have agreed that the both parties can stay together as husband and wife, that the marriage will be valid. Thank you.
All right, thank you very much. Maybe just to add on that, there's a famous case of the late WHP who got married customarily, and then later, after his passing away, his marriage was disputed to the fact that his family did not approve of the marriage or did not concede that a valid marriage took place. So their argument was mainly that certain aspects of customary law have not been fulfilled, and in that regard, they said the marriage was not valid. So courts sometimes do assist when there are disputes, but then in that case, it did acknowledge that even though a certain aspect of a customary law was not fulfilled, I think it had to do with gushing out of bile and stuff like that of a particular animal, but then it also recognized because certain events have occurred, that would equate such marriage as a valid marriage, as a valid marriage. And the matter even went to Supreme Court of Appeal, and the Supreme Court of Appeal agreed with the High Court that such marriage was valid. So even though one may say that, 1, 2, 3 elements of a customary law must be fulfilled, there are instances where the court will say you do not need to fulfill all such elements as long as certain elements are fulfilled. That is sufficient. So yeah. I think that, yes, I think that will assist in answering your question, Madam Spino. The next one, before I go to Advocate Praise, it has to do with the wills. It says, will affidavits from witnesses be sufficient for registration of marriages or of marriage? Will affidavits from witness be sufficient for registration of marriage? Madam Olive?
Remember we said that when if a person wants to register your marriage, when you have to come with, like for instance, witnesses from both families, like maybe 2 witnesses from the family of the wife and 2 witnesses from the family of the husband, as well as a Lobola letter. But the Act is not saying anything about affidavits. I don't know. I'm not so sure if, because now I know affidavits, I can go to the police station to just do an affidavit. And the police, when I get to the police station, I tell them what I want to say. And that will be an affidavit. So the Act is not saying anything about the affidavits. I don't think it's going to be an acceptable document.
And then
I can also have, but I've never come across anything like that, because no affidavits, you can just get it from anywhere.
All right, thank you for that input. The next one, I'm not clear of this question. Maybe you will assist here. It says, do the amendments address some of the underlying drivers of GBV contained in the counseling or liar given by elders to the couple during the customary marriages? Madam Mulife, do you want to comment on that?
I don't understand the question. Can you try to clarify it or shorten it? Or it just summarize it in a summary form, because I don't understand.
While Lucas is trying to rephrase the question, let me acknowledge Advocate Praise. Advocate Praise, go ahead.
Thank you. Hypothetically, a South African woman is in a fought and set relationship with a non-national, never visited the country and doesn't know the family members of the boyfriend, and now is in a process of migrating this relationship into a customary marriage. What are the measures of precaution that you can give that woman? And what will be the requirements since this relationship is with a non-national? Thank you.
Yeah, remember the Act is outlining what is a customary marriage, and in terms of the definition, it says, let me just read it to you now. Or a customary marriage is a marriage that is entered into. Customary law, in terms of customary law, it means that the custom and usages traditionally observed among the indigenous African peoples of South Africa, and which form part of the culture of those peoples. So customary marriage is a marriage that is entered into in accordance with the customary law. So according to this definition, customary law means that the custom and usages traditionally observed by indigenous African people of South Africa. So it does not say anything about the non-citizens. That is why now we are having a problem whereby a South African citizen would want to enter into a marriage with a non-citizen, because the act is silent on that. But that is something that we need to address with the new amendment that is upcoming now, so that we need to know whether we include the foreign nationals as part of the people who can get married in terms of the customary marriage. I mean, yeah, customary recognition of customary law. Because now this current one was silent on those issues. That is why we're having problems of registering those kind of marriages. Thank you.
Yeah, maybe just to add on that one, insofar as the current laws are concerned, a non-national and a South African will not be able to enter into a customary marriage, but they may enter into other forms of marriages. For instance, the one that is regulated by Marriage Act of 1961. I think so they may need to exercise their marital rights in terms of that law. But in regard to customary marriages, there is a bar for them not to marry. But maybe as a way of adding further is to say one of the things Home Affairs has been looking at in the past few years is to look at development of a white paper on marriages. And that issue where a foreign national may not be able to enter into customary marriages. It's one of those issues that the policy, in one form or the other, will seek to address. But currently, it cannot happen. Yeah, I think that is what I can also add as well. Colleagues, when I look at my time here, we are 10 minutes before 4 o'clock, and I do not see any further hands. And I see here the number of participants, it's also reducing as well. When we started, I think we were about 70 or so. And now we are about 50 yeah, about 51. Okay, maybe before I close, I see Lisicha Tefo has written on the chat. Let me quickly read, and then perhaps this might be one of the last questions we deal with before we close, because otherwise we also do not want to keep you longer than what the webinar has anticipated. So the question reads, what is the standing in law of the first meeting of the two families to discuss bride's price? In Sotho, we call it via lishasha or utiva sifero. Their meeting, remember, it would involve grooms, family paying any price. I hope I read that Sotho in a way that Madam Molefe will understand. Madam Molefe, do you want to comment on the question?
You said, what is the significance of what?
What is the standing in law of the first meeting of the two families to discuss bride's price? So I think that is the question. What is the standing in law of the first meeting of the two families to discuss bride's price?
Yeah,
I think then gives an indication of Sesotho practice.
Yeah.
You can go ahead, Madam Molefe.
I think that would be the beginning of the negotiations. Remember, we said that for a customary marriage to be valid, it must be negotiated, entered into, and or celebrated. So that will form part of the negotiations. That like who start the negotiations. That will be part of the process, but it has to be completed. If you just went and then then it cannot be complete. The marriage is not yet completed. It has to be negotiated, entered into, and or celebrated. Celebration will just come at the end. The families will decide whether they want to celebrate or not. But the most important part is the entering into and the negotiations. I hope I've answered it.
All right. Thank you very much for that response, Madam Molefe. Colleagues, I do not see any further comments on the chat, as well as anybody raising their hand to seek clarity or even to seek or to make comments. So I just want to say thank you very much for bearing with us. You acknowledge that we had quite a number of difficulties in the beginning, but you bore with us until we were able to connect and then engage with you. And we also indicated we also had issues in respect to projecting our slides. We are very sorry about that, but the slides will be made available by Mrs. Ife, and then Mr. Rwando will then distribute to all people who would have communicated such interest and so forth. Maybe before I close, I see one comment from Sizakele. I hope this will be the last one. Let me quickly read it, and this will be the last one that we take for today. So, is the issue of a husband deciding on who gets what in a customary? It appears that question is okay. So is the issue of husband deciding on who gets what in a customary marriage not fueling the issues of GBV? Because I personally think it should be stated if there are 3 wives, then all must equally share without a husband determining on which wife gets what share. Madam Molefe, do you want to comment on that?
Yeah, I think Advocate Stevens has already answered that one to say that, remember, when you bring the second wife, you already have acquired a certain property with the first wife. So in order to protect the first wife, you need to draw up a contract to stipulate in that contract what is going to happen to this property that you've already acquired. And even moving forward, how are we going to distribute your property that you acquire in the future with this other additional wife or wives? I hope I've answered you.
All right, thank you very much. Maybe just to add as well, I think we need to remember, colleagues, that in the Gumede case, what happened is that property was bestowed on the husband as a family head, and the wife did not have any say in respect of the property of the household. So the changes that are brought about by the Customary Marriages Amendment Act of 2001 are primarily to deal with that aspect, to say a husband is not the only person who has control of assets that people collect during marriage, but both parties are equally responsible. So I think that is the area we need to be aware of, to say the husband is no longer in control of everything, but the wife is also equally in control as the wife. So I think that's quite important to note as we close. So colleagues, thank you very much for staying with us until this time. We also thank you very much for your insightful inputs and comments and questions that made this engagement very lively. And Madam Mulife, thank you very much as well for your presentation. Mr. Luando, you know, in the beginning, you were busy trying to make sure that everything is up and running. And thank you very much for your patience and all of you colleagues. Thank you very much for participating in this webinar. Insofar as future webinars are concerned, Mr. Luando will communicate. So I officially close this meeting. Thank you very much. Bye-bye.
Thank you.
Thank you. Goodbye.
Bye.
Thank you. Thank you. Bye.